a 7-time member of parliament called Mahendra Prasad. Lord, he has passed away now. He had extensive businesses and properties. One of the probably the richest MP who has been in Delhi for some 50 years. So, Lord, he had a wife called Satula Devi. And he was living with a lady called Uma Devi. Both claimed to be wives. Now, obviously, Lord, the dispute is about the estate. Estate is large. So, Lord, what has happened is the MP, Lord, made a registered will in 2011.
Probate suit pending, declaratory suit, probate suit pending.
The daughter-in-law, not
Yeah. Blood, sorry. So the wife, Lord, files a suit after 50 years. The wife, Lord, cut it short, the wife has filed a suit. She's also dead now. She files a suit. Yes.
Also coming into picture, we do not know where it manufactured, who has tested them, where were they brought, and all these things. But these are all question of facts, essentially.
But Lord, I will therefore not tell your Lordship any
The High
dispute.
Court has merely paved way for the determination of these issues. The real central issue will be in the probate,
That's a probate.
probate
So
matter.
probate is going on.
Going on.
There is no dispute on that.
All other issues are also.
Lord, the law is, with great respect,
Yes, ये करके रखी है and order दीजिए.
Wait, phase 1 has to partition.
Lord, your Lordship, sorry. Your Lord. What am I saying? He's saying the same thing.
Yeah,
I told you.
Anything. We'll have an easy way out. Let it be decided unenforced.
I know that of course. Oh, let there be a preliminary issue.
Exactly. 14. Or a 14.
So, my Lord, I will tell your Lordship some 2-3 facts. I am not taking your Lordship to any disputed fact. Yes.
The suit should be decided or taken up after the probate is decided.
That is one way.
But restoration of suit by the High Court
Stay of suit.
But may I just...
Better course which the High Court division may rightly observe is let the suit await the probate decision. Probate is an in rem decision. It should be. And let us say, Mr. Rohatgi, they are not able to prove the probate, have the probate on the will. Your suit would naturally revive and what you say as intestate succession and partition, everything will come to the fore.
No, so only one thing I want to say. Lord, I quite understand what your Lordships are saying. I don't, Lord, have a quarrel really. Only one thing I want to say. So, Lord, the suit is fine. Also questioning the will, that, Lord, is not possible if a probate is pending. That is your Lordship judgment. So now let's keep that aside. Now, Lord, for the other reliefs, as the Chief Justice put it, she says that I gave gold in 1971 to my husband, who was an MP. He was not a qualified engineer. And he used that gold to set up a vast empire today, which is of thousands of crores. And therefore, my Lord, that law that I would be entitled to this, that, and the other because it was biased treason, etc. Now, what is important is the suit is filed 50 years after, my Lord, this so-called 1971, when she gave the gold and the husband started living with another lady in 1974, etc. Now, what is important is this, my Lord. She also filed a writ by saying that the husband was suffering from dementia. So she said, appoint me as a guardian, I'd like him kind of a situation, because the Mental Health Act doesn't apply, this doesn't apply, etc. In that spirit, my lord, she has expressly stated that all the properties are of the husband, and not, my lord, that she provided, my lord, the corpus by way of this gold, etc.
Properties in the sense that she is not disputing in the suit also. The properties actually were in the name of the husband. Were belonging to him.
But, my lord,
Now saying the source of generating these
my lord,
properties.
does it take 50 years, my lord, for somebody to realize a source?
But you see, the only difference is that suppose a complete stranger comes and jumps into a pending litigation saying, no, this entire empire is my creation. We will be the court will be very, very doubtful in accepting it. She is not a stranger. She is, after all, the first wife of the.
And she has filed a suit, my lord, against me. I am the wife of predeceased son of the plaintiff. I mean, look at what is, my lord, going on. I mean, she had 3 sons, my lord. I am one of them, one branch. The other 2 branches, my lord,
Other two disowned.
they were disinherited in the will. So the 2 sons and the mother gang up, my lord, against the predeceased son.
Because they are threatened by the influence of the other lady. The other lady's influence appears to be overwhelming.
So, my lord, with respect, my lord, the 1 or 2 things I want to say.
The best way is let the probate proceed. In the meantime, let this suit be kept in abeyance.
Very well, Lord, if that is the Lordship's pleasure, because the judge
Actually,
dismissed the
In
suit.
the impugn order of law, they've already been consolidated, so it's before the same judge. I'm sure that.
The consolidation is
last
something
order-
different,
last
but it
order
must
is
await.
see at
It
page
must
71.
await, because
And
consolidation
the
again
judge
creates a
has
problem.
given the liberty. There is one small issue in that note only. There is one witness to be examined, who is the only witness who is alive today who can talk about this gold. So that witness examination should happen, not for which an order is.
No, I'm
So
sorry,
Lordship
but the
will say
suit
that-
must await,
that
otherwise the suit is hit.
Just see the last paragraph.
One second.
Just see the last paragraph, 71.
Lord, the judge has mixed up the facts of the LPA of this. It's
No, the IAF
he should have written a separate judgment, Lord, all LPAs are mixed up, all the
about the
suits are
court.
mixed up.
If he dies, Lord, how will the suit be decided? That's the only problem.
Suit
I'm
has
not
to
saying
await.
suit should be decided before the probate. Suit will have to be decided after. But the proceedings should go on in the suit. That's all.
What do you mean proceedings should go on? You will
Because
have
there
the
is an
conflicting
important
evidence.
examination under order
No, I'm sorry, Lord, that
1860.
can't be. You will then have conflicting positions in a suit and a probate. How can that be?
There is already a consolidation order at para
That should
71.
be set aside. If there is.
Different jurisdictions.
They're completely different jurisdictions. One is in REM, one is in.
No, it's before the same judge now. Right together. Page 45, Lord, it is both are on the original side.
The original side is all right, but the jurisdictions are completely different.
And that your lordships also have said for
That instead of word consolidation, the suit and the probate proceeding will be before the same judge. But
that's what has been done, Lord. Already
But
done.
not one after
Para
the other.
71. Just see para 71.
The lordships decide one after
No,
the other on
what
the
is
same
the
day.
consolidate? So that
Consolidation
can be
cannot.
deleted.
Yeah.
The
Character is
second-
different.
The
Consolidate.
second thing, the suit will continue, the evidence, etc., can continue, but no,
Yes,
there
that
will
is
be no final decree.
no,
till the
absolute.
Probate matter is decided.
That's
Lord,
That will help.
But
the
it
party.
will lead to conflict, my lord.
No, evidence will not conflict. Evidence, only evidence is to be recorded.
It is before the same judge.
It will rather help the party. Both sides will be benefited.
The division bench also was of the view that the suit can be stayed.
Yes.
It's recorded.
The suit-
So if the suit is stayed, my lord, it can't proceed with evidence. Your lordship must see that. They have not challenged that. Just see that part.
There are certain exceptions to that, Mr. Rodgi. What Mr. Singh is pointing out is also very relevant.
Yes.
There may be a situation where a person is in poor health or a person may be leaving the country, etc. In these cases, there can be an evidence recorded subject to the maintainability. of
That's
the-
right.
Time be fixed. Time be fixed.
Yes, sir. Let us-
Say,
My lord, para 70 records that
Yes, we've
contention.
seen that. We say.
Yeah.
Correct.
And in any case, my lord, whenever the suit or whatever proceeds should be uninfluenced by this order.
so
Any other proceed, because this will have an impact.
say leave granted. We have heard and seen counsels.
It's fine.
on behalf of the appellants as well as friends in counsel representing the respondents, contesting respondents who are on caveat. Upon consideration of the matter in entirety, we affirm the view taken by the High Court so far as a restoration of the suit is concerned.
CSOS 203 of 20.
So far as a restoration of civil suit OS 203/2022 is concerned.
However, instead of
However,
probate proceeding.
we deem it appropriate to modify para 70 and 71 of the influence judgment to the following limited extent. One, I,
Because we have said it can be stayed, we consider.
the probate proceedings and CS in bracket OS 203/2022 shall be entrusted to the same learned single judge as per the prerogative of Honorable Chief Justice of the High Court. While both the matters, both the cases shall be preferably taken up for hearing simultaneously, there shall be no formal order of consolidating them. The same shall not be taken to have been consolidated.
It's that High Court has original side, so it can be taken up by the same High Court.
One after the another, but there shall be no consolidation of both the cases.
Shall be open to the plaintiff and then to read evidence in the event.
After 20 years.
The plaintiff in CSOS 203/2022 shall be at liberty to lead plaintiff's evidence. Especially if especially if the production of such evidence in near future is likely to become difficult.
Already application is there, Lord. Order 18 Rule 16. Application is already there.
All right. The plaintiff shall be at liberty to pursue the application under order
18 Rule 16.
16 CPC.
Subject to the maintainability
And the suit may proceed. Final judgment should await the trial.
The plaintiff may proceed to bring the evidence on record in the suit. However, no final adjudication of any issue
In the suit.
in the said suit shall take place till the
Probate
proceedings are finally decided.
And if you not put expedite also.
Probate is expedited, it will bring an end to blood.
It will be in the interest of,
You get the probate dismissed.
it will be in the interest of justice for both sides. If the learned
Any other proceeding, Your Lordship, say, because there are all kinds of proceedings.
expedite the proceedings in the probate as well as in the probate case. That is first to decide.
Yes, yes. I also want that. There is no question.
You win
And
the
that is what your lordships have done it in other cases also. That probate will be decided first, but both can continue.
Next probate. The civil will stand disposed of upon.
And Lord, the suit number is 203 of 22.
Yes, that is correct.
203.
Both suits, my lord. Both
Actually,
suits
no,
will
no,
be
no.
decided
No, no,
uninfluenced
please
by any
don't.
of them.
There is something, there is a hidden.
and uninfluenced, sir. There can be the pleadings in the declaratory suit would naturally overlap as a suspicious.
It's a judicial observation. They have been read against us in fact-finding proceedings.
Suspicious circumstances.
Those judgments are challenged and dismissed, and still they want something to be. Deeply obliged. Lord.
Thank you. Item
Lord, fully
24.
uninfluenced by other proceedings in both.
And always.
That may be recorded, my lord, because all fact findings have been
Never influenced
vindicated.
by anything.
That's the only limited request, my lord.
We
We
are
are not
never influenced by anything.
very well, my lord. I'm grateful, my lords. My lord, the testamentary case number 1 of 23 may be recorded in the order because only CSOS is reflecting this.
If you can give the number of probate matter, we can mention that.
Yeah.
Very well, my lord. I'll give.
Testamentary one, yes.
Yes.
20.
Item 24.
That's it.
Yeah, yeah.